We're at the beginning of one of the big themes in this unit, and that is the regulation of online intermediaries. As you start to go through the material and the cases about the regulation of online intermediaries, I'd like you to keep one question at the front of your mind, and that is, what is the goal of the regulation that you're looking at, and whom is the regulation targeting? Because when we look closely, what we find is that often the laws which purport to regulate intermediaries are not really about the intermediaries. What they're about is targeting end users, ordinary people who are using the internet for particular purposes. So copyright is a really good example of this. In recent years, copyright owners have argued that intermediaries like ISPs should be regulated or should be subject to legal liability if they don't help to stop copyright infringement. They make arguments that ISPs are responsible because they provide the internet over which people infringe. Really though, the goal of making ISPs liable is not just to change the ISP's behaviour. What the goal is that by putting regulatory pressure on ISPs, the hope is that ISPs will then put pressure on their users in order to avoid their own liability. So they will take particular actions like sending warning notices or suspending or disconnecting people's internet accounts. And this pressure in turn will encourage users to alter their behaviour by not infringing copyright. So even though the laws apply to intermediaries, the real target are the end users, ordinary people. Now this might seem like an obvious point, but it's an important one, and it's important because it's a point that is often obscured in the literature and in the case law about intermediary regulation. And that's partly because we have a two-party legal system, which easily then obscures third-party interests. So in intermediary regulation or intermediary liability cases, we have two parties. We have the plaintiff, who is the person aggrieved. So in copyright cases, this is the rights holder. And we have the defendant, who is the intermediary. And then arguments within the case or within debates in society then focus on what the intermediary can do to combat wrongful behaviour. So they focus on the technological capabilities of the intermediary or the question of who pays for the regulation, who bears the costs of the regulation. And these are issues very specific to the intermediary and to the plaintiff party. The interests of the users get lost in these debates. And users do have legitimate interests online. They have interest in accessing content, in being able to express themselves online, in having debates or engaging in self-development or creative play online. They have autonomy interests in accessing content at times and places that are convenient to them, so around their work hours, for example. New business models which respond to some of the problems we have on the internet, like Netflix, do respond to these user interests. So Netflix responds to this autonomy interest by enabling people to view television programs or movies at times convenient to them. The business model responses tend to do much better on user interests, but the legal responses often don't. So the case law will often treat, in copyright cases, users as this sort of faceless group of nefarious pirates without actually interrogating what are the actual interests of the users and are they legitimate and how can we respect those interests while we regulate. So the interests of users and the people who are the real targets of regulation is something to keep in mind as you look at all the content around intermediary regulation. It may not be such a pertinent issue in some circumstances, such as the regulation of hate speech, but it's very much an issue in cases involving content like copyright infringement cases. So as you read the materials, as you read the case law, I invite you to always be asking, are the end user's interests being considered here? Are users even present? Are they being treated as criminals with no real basis? Or are their interests actually being accommodated in the regulation?